Good afternoon and welcome. Thank you for joining us today. I am Derek Seimer, Chair of FAR, and welcome to the FAR webinar, DEI Initiatives in the Crosshairs of the Administration, What Nonprofits Need to Do to Mitigate Their Risk. For those joining us today that are not familiar with FAR, FAR is the area's only membership association dedicated exclusively to not-for-profit business leaders. For the past 40 years, we have provided great speakers, timely topics, and professional development in a relaxed environment where professionals come to network and exchange ideas and stay informed about the latest issues and trends affecting their organizations. Consistent with our theme this year, Moving FAR Forward, events like this webinar demonstrate that FAR is nimble in engaging our members around timely issues that matter to them. We'll be looking at more webinars and trying out new locations and times for our monthly meetings in the months ahead, so please be on the lookout for that. As an example, next week on Thursday, March 6th at 12 p.m., we will be hosting another webinar, but this one will be information gathering and will be a virtual town hall soliciting feedback from all of our nonprofit members, past members, and future members. There's a link in the chat today to make it easy for our nonprofit guests here today to register for that town hall right away. Also, if you are interested in FAR membership, please reach out to us for more information. The email and link for membership will also be in the chat. And lastly, I'm excited to announce that FAR will be hosting its inaugural awards program this September. It will coincide with our annual business meeting and our fall kickoff event. Please stay tuned for more information on that. And before we get started today, I just have a couple of additional housekeeping items. First, this webinar is being recorded. All attendees will be muted and cameras off. If you do have questions, please use the Q&A portion of the webinar. And if you prefer, there is an option to pose your questions anonymously. The chat will not be monitored for questions, so please use the Q&A. We will do our best to get to every question today, but if we miss yours, rest assured we'll send them to our speakers and get a response to you. And as a follow-up, you will receive a survey, and upon completion of the survey, you will receive a link to get a recording of today's webinar. And now I would like to introduce today's speakers. We will be hearing from two expert nonprofit attorneys from the Tenenbaum Law Group. First, Jeff Tenenbaum is widely regarded as one of the nation's leading nonprofit attorneys. He's also an accomplished author, lecturer, commentator, and expert witness on nonprofit legal matters. As a managing partner of the nationally recognized Washington, D.C.-based Tenenbaum Law Group, a six-attorney boutique firm focused exclusively on the legal needs of nonprofits, Jeff counsels his clients on the broad array of legal and sensitive business and governance issues affecting nonprofits today. Jeff is the author of the ASAE published book, Association Tax Compliance Guide, which is only slightly more popular than his second and perhaps more interesting book, Quarantine Cocktails. Jeff is joined by his associate, Kevin Serafino, who is an associate at Tenenbaum Law Group. Kevin advises nonprofit organizations on a broad range of legal issues. He counsels public charities, foundations, trade and professional associations, and social welfare organizations on formation, federal tax exemption, governance, and major transactions. He also focuses on advising politically active organizations on federal and state lobbying, ethics, and campaign finance law, and assists in designing compliance programs to complement high-impact advocacy work by nonprofits. And with that, Jeff, I hand it off to you.
Thank you, Derek, and welcome everyone to our webinar here today. We have about an hour and 10 minutes to get through a lot of information, a lot of important information about one of the hottest topics facing the nonprofit community today. It's a topic that we have heard about, my colleagues and I, from literally day one of the Trump administration, which started last month. It has not stopped. The concern is real and palpable. The concern is real not just for those nonprofits that receive federal awards like grants, cooperative agreements, and contracts, some of which we're going to talk about here today, I know some of you on the webinar today represent or advise nonprofits that do receive some form of federal awards. And of course, there's going to be a high interest in what we're talking about here today from your perspective. But equally importantly, knowing the FAR crowd fairly well, my guess is that there are more of you on the call today that are with organizations that do not receive federal funds. And for those of you who think that everything that you've read and heard about in terms of the administration's executive orders regarding anti-DEI initiatives and similar administration priorities, if you think that only those nonprofits that receive federal funds are ones that need to pay attention to it, that is absolutely not the case. And we're going to explain why that is the case today. Like all of the webinars that I do and we do, we're going to, of course, focus on explaining the background, the context, how we got to where we are, kind of the lay of the land in terms of the law in this area, which is very much an evolving, moving target, maybe more than any legal matter that I can remember dealing with or observing in the last 30 years that I've been practicing law, which definitely makes it more challenging. We're certainly going to spend some time focused on that, but we want to spend more of the time focused on what I believe is the most important, which is the takeaways for you, the practical guidance, tips, suggestions. So once you understand all of this, what should we do about it? What are our options? What are our different steps that we can take to help mitigate our legal and financial and business and reputational risk? Kind of those practical takeaways are what we have been focused on with our clients, literally on a daily basis, doing reviews for our we have hundreds of nonprofit clients. We're not doing hundreds of DEI related reviews, but we are doing quite a number right now, examining all of their DEI related initiatives and programs and activities and policies, helping to analyze their risk, legal and otherwise, under these various different aspects of the law that we're going to be talking about here today, and then giving them practical tips, guidance, and suggestions for some things that they might want to consider to do to mitigate that risk. I've been asked a number of times by clients in recent weeks, what are the biggest risk issues? What are the biggest things that we need to focus on? If we do X, Y, or Z, do we need to be concerned? And the short answer is that every single situation, every single client, every nonprofit organization, their risk tolerance, their risk exposure, legal and other risks. Sometimes it's business risk, financial risk, risk of angering donors, supporters, exhibitors, attendees, sponsors, advertisers, either because you're taking positions on one side of the political aisle or the other. And we've seen all of that. But every situation is different. Every initiative, DEI-related initiative that nonprofits have seems to be a little bit different. And so the analysis for each organization is going to be different. And that's going to be one of the takeaways here today. Kevin's going to start us out by kind of giving an overview of kind of the lay of the land at the federal level, where we are on this day, February 25th, at this point in time. And he's going to talk about some of the legal risk from the administration's DEI-related executive orders and other actions. He's also going to talk about the 2023 U.S. Supreme Court decision, which banned affirmative action in college admissions, which, while not directly relevant to the discussion and analysis today, is very much relevant in indirect ways. And it has been very relevant for the last almost 2 years in terms of how cases have proceeded through the courts. So it's important for you to understand that as well. And then I'm going to come back and talk about risks, legal risks in the employment area and in the area of contracting. Then we're going to come back to all of the practical tips and suggestions I promised, followed by hopefully a lot of time for Q&A. We know you're going to have a lot of questions. I've done 2 webinars to date on this topic. Kevin's on one of those with me. In both cases, we were flooded with questions, all of which we could not get to. That'll likely be the case today, but we're going to do our very best to get to as many as you can. So like Derek said, pose your questions in the Q&A feature of the webinar platform, and then Mickey will be posing those questions to us. Feel free to pose them as we go along. If you do, some of those are likely going to be answered by things that we will be discussing as we go, which is the norm and typical, but feel free to pose them now as we go along, and we'll get to as many of those as we can. So with that as background, Kevin, I'll turn it over to you.
Thanks so much, Jeff, and good afternoon, everyone. I'm going to start by just kind of giving an overview of the executive orders and other administrative action that we've seen since the beginning of the Trump administration, really to tee up the discussion of where the biggest risk areas are for nonprofit organizations in terms of compliance with these various administrative actions. And some of these, this is a very quickly evolving area. Some of the most recent action that I'm going to mention today was taken just last Friday, and that was a court injunction in Maryland. So it just illustrates how quickly things are changing. Like Jeff said, this is a bit of a snapshot in time. This webinar may be completely out of date by this time next month. So just something for everyone to keep in mind that this is a very quickly changing area that nonprofit executives should make sure they're staying on top of to the extent that they can.
Well, Kevin, let me interrupt for 1 second. It's certainly conceivable or possible that the executive order specific part of this webinar might be out of date depending on what the courts do. And we know there's going to be appellate challenges likely going all the way up to the U.S. Supreme Court. And we'll have to see and wait how that plays out. But one of the important takeaways from today is regardless of all of this, regardless of the legal state, the enforceability, the enjoinability of the executive orders and other administrative actions, regardless of what happens with federal funding of DEI-related grants and research projects and contracts and whatnot. There is no question that this kind of anti-DEI climate is here for now, at least, is not going away. We've already seen it play itself out in the courts through litigation, particularly following the 2023 U.S. Supreme Court decision, and we're seeing it play out in the states in terms of state action, particularly in the politically red states. And none of that is going away anytime soon. We've been writing about this, doing webinars on this for the last 2 years, even well before the Trump administration took office. So I just want you to keep that in mind. We're going to explain what I mean as we get into it. And what's going on at the federal level is very, very important, but it's not the only ballgame in the DEI town.
Right. And like Jeff said, I think the Supreme Court decisions from 2013 on affirmative action are a bit of a new North Star for a lot of the legal developments that we're seeing. And we'll get into that in a second. But that's just one of the things that's going to be a more durable element of this analysis. But like Jeff said, the administrative actions and related court challenges are a very dynamic area. So we're dating back to the early days of the Trump administration to start here. Sorry, the second Trump administration, and two executive orders that were issued on January 20th and January 21st, respectively. And they're a little bit confusing because there's so much overlap between them, and also because it doesn't seem like they coordinated terribly well between them because they use different terminology. It looks like there were different authors, even though they address somewhat similar subject matter. So the first one was issued on January 20th, and it really, at its core, is addressing environmental justice issues, which in many ways overlaps with DEI programs. Specifically, this environmental justice executive order terminated federal agency DEI programs that are called, discriminatory programs, including illegal DEI and mandates, policies, programs, preferences, and activities in the federal government under whatever name they appear. So it also terminated DEI and environmental justice positions within federal agencies that had been addressing environmental justice issues for the Biden administration. It also directs agencies to provide to the Office of Management and Budget a list of federal contractors who have provided DEI training and DEI training materials to agency employees, and a list of federal grantees receiving federal funding for DEI and environmental justice programs since the start of the Biden administration. So that's the first executive order that we're talking about that was issued on January 20th. The very next day, January 21st, is a different executive order that I think has received a little bit more attention, mostly because of its broad policy statement. Directing executive agencies to terminate all discriminatory and illegal preferences, mandates, policies, programs, activities, guidance, regulations, enforcement actions, consent orders, and requirements. So, it's very broad language that doesn't have an accompanying, order for how it's going to be executed, but that is just the broad policy statement that the Trump administration made with this executive order. So getting into the nuts and bolts of it in terms of what it directs agencies to do, it revokes a handful of prior executive orders, some of them dating back to the Civil Rights era in the 1960s, including non-discrimination orders in the federal government and in federal contracting. It further directed executive agencies to terminate all discriminatory and illegal preferences. There are a couple federal contracting provisions where it directs agencies to, revoke certain DEI-related federal agreements, and it requires federal grantees to certify that they do not operate any programs promoting DEI that violate any applicable federal anti-discrimination laws. The final piece of this executive order that caught a lot of people's attention was its private sector enforcement provisions, where the executive order directed agencies to submit recommendations to enforce federal civil rights laws and encourage the private sector to end what it considers illegal discrimination and preferences. So I think the biggest takeaway that we have from some of these executive orders is that it uses very broad language that is poorly defined in many cases, does not define what illegal and discriminatory preferences are. We do have a long-standing body of federal law and case law addressing discrimination issues. It makes very tangential references to those laws, namely the Civil Rights Act of 1964 and the Students for Fair Admissions case, which is the affirmative action cases at the Supreme Court from 2023. But it makes sweeping generalizations of all DEI programs without actually addressing whether they are illegal under federal law. So I think, one of part of the intent of that executive order seems to have been to scare people, to make them really claw back their DEI programs of whatever kind, for fear that they may be considered illegal. But it's important to remember that executive orders themselves do not create new law. They enforce existing law, and they direct federal agencies in how they should enforce existing law, but they are themselves not new laws. So that's part of the tension that we're seeing, and the difficulty that nonprofits are having responding to these is fear that they may be targeted for enforcement, even if their DEI programs are not illegal under existing law.
Yeah, Kevin, let me add a couple of corollary points there that I think are worth noting. First, it goes without saying, but everything that Kevin has discussed so far pretty much is limited to nonprofits that receive federal funds, federal awards, grants, cooperative agreements, contracts, or loans. And even to a small extent, but it is largely limited to that. Kevin's going to talk about some other things like an attorney general memorandum that goes further than that. And we've seen some other administrative initiatives that go beyond that. But so far, largely limited to those that receive federal funds. Second point is that you might have heard Kevin refer to certifications that are required. And we're starting to see this play out now through different federal agencies where any federal award recipients, we're not seeing it with because a lot of these federal awards have been paused while the administration does a deeper dive review, despite the fact that some courts already, including a court in Baltimore last Friday evening, ordered that there be no pause and that the administration's kind of withholding of federal award funds needs to stop right now, that it's not lawful. The spigot has clearly not been turned on in any significant way. It's been sporadic. But one of the requirements that some federal agencies are requiring of their award recipients is to affirmatively certify that the organization does not operate any programs, not just with federal funds, but does not operate any programs promoting DEI that violate any applicable federal anti-discrimination laws, basically that violate the law in the anti-discrimination area. And two, they tie that. There's I won't bore you with the specific language, but it ties it to the Federal False Claims Act, which basically says the organization is asserting that if it's not being truthful in this statement about compliance with all applicable federal anti-discrimination laws, then that can give rise to a False Claims Act claim against the organization, which is the longstanding federal law that basically makes it illegal to defraud the federal government, has both civil and criminal penalties. Very significant. We're also starting to see evidence that some of these certifications are going to need to be flowed down to subawardees. And many subrecipients, subawardees, like grantees and contractors, have subgrantees and subcontractors to help them carry out their work. Very common. Your organization may be one of those subawardees, and we're seeing some of these certifications have to be flowed down to the subrecipients beneath them. This is a very significant certification that has to be made, especially when we don't know what is illegal. We have seen some administration pronouncements, even I think a reference in one of the executive orders that basically said or implied that all DEI programs are illegal on their face. We know that's not what the courts have said. Absolutely not what the courts have said. The courts have drawn fine lines that those lines are likely evolving and likely will evolve through the U.S. Supreme Court in the coming months and years. But clearly, the courts have not said that all DEI initiatives are illegal. But if you have to certify that your DEI initiatives do not in any way violate any federal anti-discrimination laws without any definitions of what that means, that's definitely very disconcerting. All right, Kevin. Sorry about that.
No problem. Thanks, Jeff. Thanks for adding those kind of clarifying points. I think there were a lot of questions after these executive orders came out, and a lot of that ambiguity is exactly what Jeff just touched on. But Jeff also mentioned an additional kind of clarifying document that was issued by the Department of Justice. So on January 5th, immediately after her confirmation as the Attorney General Pam Bondi issued a pair of memoranda to U.S. Department of Justice personnel. And in those memoranda, she directed the department to eliminate practices related to DEI that are within the department, but also directed various elements of the DOJ to begin investigating, eliminating, and penalizing private companies and universities, including nonprofits, that have illegal DEI programs. Again, we did not have a great sense from this memo what illegal means, but they also continue to use the term illegal and discriminatory. So, they're trying to, allude to programs that are far broader than the kinds of programs that the courts have traditionally found are illegal and discriminatory. But so far, we don't exactly know what they mean when they say that. They also directed officials to enforce civil rights laws against some of these programs. But again, we have a long-standing body of law that tells us what is illegal and what is not. We just don't have a great understanding of how the administration is going to interpret what is illegal and not moving forward. So this is a big moving target that unfortunately nonprofits have to try to keep up with at this point.
And like Kevin just said, like that DOJ memorandum directed the DOJ Civil Rights Division to recommend enforcement actions and other, quote, appropriate measures to encourage the private sector to end illegal discrimination and preferences. And among the recommendations that Attorney General Bondi requested are proposals for criminal investigations and for up to 9 potential civil compliance investigations of, quote, large nonprofit corporations or associations, foundations with over 500 million in assets, state and local bar and medical associations, and others. And so this goes beyond just federal award recipients, and other federal agency heads were directed to also identify up to 9 potential civil compliance targets, including in the nonprofit space. So this has raised a lot of concern among nonprofits that are not federal award recipients, that they may be targets because of their anti-DEI initiatives. So it's something that we're very much paying close attention to.
And then the last piece of kind of current developments that I wanted to highlight, we mentioned earlier that a court on Friday in Maryland issued a temporary restraining order on the DEI executive order, mainly because of First Amendment concerns. And the judge stated that in their longstanding programs that we know are legal, so that this, the DEI executive order raises significant First Amendment concerns around communicating principles of non-discrimination that have been in civil rights law for decades. So that is something that we expect to get litigated further. For other additional challenges independent of this Maryland challenge will probably start cropping up using some of the language that the judge in Maryland used. I think that's providing a bit of a roadmap for organizations that are challenging these executive orders. So we expect that to be a developing situation with respect to the legal challenges in federal court.
Yeah, that Baltimore federal judge ruling. By the way, I think, Kevin, it was a preliminary injunction, not a temporary restraining order,
Oh,
which
sorry.
which has a longer duration, and that's important. But if you read through the order, it's pretty compelling on First Amendment grounds, basically saying longstanding law makes it illegal for the federal government to kind of penalize based on speech by what people are saying. And that has been, one of the constitutional bedrocks of the First Amendment for decades in jurisprudence and the law. And so it's something very much worth noting. But that order essentially put the salient parts of both of these DEI related executive orders on hold. All right, Kevin.
So moving a bit further into the past now, we've talked about some of the more recent developments in the executive orders, their interpretation, and court challenges. We're going to back up just a second to talk about a bit of the legal framework that this is being considered under, which is the 2023 affirmative action cases at the U.S. Supreme Court. As most of you probably heard at the time, cases against Harvard and the University of North Carolina challenged the use of race-conscious admissions by these major universities. The real hook for challenging them was that these universities, like almost all colleges and universities, are recipients of federal funds through student loan programs and grant programs and things like that. But what we've seen is that this is really being viewed as an indicator of where the state of the law is going. One of the biggest, I guess, prognostications that many observers made afterwards was that this is probably going to start infiltrating into other areas of civil rights law. I think the first target that people think it will move towards is Title VII of the Civil Rights Act, which bars discrimination in employment. And Jeff is going to talk about that a little bit in just a moment. But the Students for Fair Admissions cases did not directly apply to nonprofit organizations that do not receive federal funds. But again, as this continues to evolve, we think that it could and is moving in that direction. It signaled a change, really, in how the federal courts are examining discrimination issues. It also applied in some of the recent litigation against other organizations that have DEI-related programs. This is private litigation. It's not being enforced by the federal government, but the most prominent of those cases was a case called Fearless Fund. It was a grant program operated by it was a private equity or a similar organization that was giving grants to businesses owned by Black women. It was challenged in the courts, and the courts found that because it is a contract, and Jeff's going to get into this in a moment, because it involves contracts such as accepting terms and conditions for entering the grant competition, that discrimination based on race was impermissible. I think that's going to be, another case that it wasn't appealed. I think a lot of people think that because the plaintiffs did not want to the defendants did not want to create bad law by appealing it. But it is an example of how some of these principles are coming to the fore against nonprofit organizations. It was a case brought by the same group or the same man that created the Students for Fair Admissions group that sued UNC and Harvard. So we see it's a from the political right, organizations that are challenging various nonprofit programs based on their DEI elements. Most of these cases have settled, so we have very little case law to actually go after or to actually analyze. They've been settled. The organizations changed their selection criteria or their eligibility criteria with respect to that DEI program. And sometimes we know what changes they made, but we don't have a formal kind of judicial interpretation that gives us an indication of where we're going on this. So that is kind of the lay of the land. It tees up Jeff to talk a little bit more about the employment and the contracting elements that are, two of the three major risk areas that we look at when we're advising clients on their DEI programs. federal funding, which we discussed a little bit earlier, employment, and contracts. And Jeff is going to get into those other two.
Thanks, Kevin. And I'm actually going to add a fourth, which at the current snapshot in time is not as much of a risk analysis factor for us, but I think will be in the coming months, and that's state laws, applicable state laws in employment and contracting and in other areas. So first off, I'm going to talk about each one of those. Kevin talked about the federal activity, U.S. Supreme Court, executive orders, U.S. DOJ, memos, memoranda, etc. I'm going to talk about the contract issue that Kevin just started to tease out. Second, employment law, and third, what's going on in the states. So let me start with contracts. So believe it or not, the law in this area has been around since, this is not a typo, 1866. The original Civil Rights Act was passed after the end of the Civil War. And among other things, it was designed to protect the civil rights of people who were freed from enslavement. And one aspect of that law, which is now codified in the federal code in 42 U.S.C. Section 1981, so I'm going to refer to it as Section 1981, prohibits discrimination on the basis of race in contracting. And the idea was that federal law wanted to help ensure that those who were freed from enslavement were able to make a living, enter into business contracts, things like that, and not be discriminated against on the basis of their race. It is solely limited to race, not other protected characteristics like gender or ethnicity or religion or other things like that, just race. But it's been around literally since 1866. And really until, at least in a meaningful way, until the U.S. Supreme Court's 2023 affirmative action decision, we really never saw any meaningful litigation based on that. But, hark back to that U.S. Supreme Court decision, which basically adopted a reverse discrimination argument that, by having certain preferences for people of certain protected characteristics in college admissions was discriminating against those who don't have those protected characteristics. Think, for example, white guys. And that reverse discrimination logic reasoning, as many, including us, when, I remember writing an article after that decision talking about the fact that while that decision was limited to college admissions, that the reasoning behind it could clearly be expanded into a lot of other areas. And sure enough, our friend Ed Bloom, I say that in jest, our friend Ed Bloom, who was the individual who brought the college admissions cases, formed another nonprofit. That's been his MO, is to form nonprofits to bring these cases in court. He formed another nonprofit called the American Alliance for Equal Rights, which, as Kevin said, sued the Fearless Fund. Fearless Fund is a nonprofit 501c3 organization based in Atlanta. Fearless Fund had a single member LLC called Fearless Fund Management, which was or maybe not single member, but it was a Black women-run venture capital fund that made $20,000 grants to Black women-owned small businesses. Ed Bloom's group, the Alliance, sued the organization, as Kevin said, based on the same kind of reverse discrimination line of thinking. Had some early success in court. Ultimately, Fearless Fund decided to settle the case, abandon its program, and decided not to appeal. It was settled last September. Ed Bloom's, and that was all based on Section 1981. That because these grants involved contracts, because those contracts were limited to Black women-owned businesses, that was discriminatory, violated Section 1981 of the original Civil Rights Act, and was illegal. Ed Bloom also filed lawsuits in 2023 against two large national law firms that had paid diversity fellowship programs for many years that were aimed at bolstering diversity and inclusion in their attorney ranks. The lawsuits alleged that the fellowship programs, which were limited solely to certain underrepresented groups in the legal profession, such as students of color, are a violation of Section 1981 by illegally discriminating against students on the basis of their race. I believe that both lawsuits were settled and the law firms agreed to abandon those programs. There are other lawsuits that are working their way through the courts based on this same line of thinking, and they apply to and potentially apply to all sorts of nonprofit grant fellowship, scholarship, internship, and similar programs wherever there is a contract involved. And by a contract, I don't necessarily mean a written signed contract in the classic sense of the word. As lawyers learn in first year of law school and contracts class, there are implied contracts, there are oral contracts, there are all sorts of contracts. Even, for instance, when your board members, if you engage in the best practice that we recommend for our clients, you have your board members agree to something at the beginning of their term, which says that they agree to abide by your nonprofit's conflict of interest policy and confidentiality obligations. Sometimes we include copyright assignment provisions, agreeing to adhere to a code of conduct, things like that. And that is a contract. We actually we draft those. We have those contracts that we provide to our clients to utilize. If, like some of our clients do, you have certain board slots that are limited to people of certain protected characteristics, and there's a contract involved for those slots, that sort of practice even potentially falls under this rubric. We've also not yet seen, at least to my knowledge, either the federal government under this administration, well, that's probably too soon, like the Department of Justice, or state attorneys general from red states bringing actions on behalf of the federal government or on behalf of their states based on Section 1981. But I fully expect that we will. Would not be surprised to see this Department of Justice and this Attorney General bring a case in this area. And so it is one of the key areas when we are analyzing our clients' risk factors in the DEI space that we are analyzing any program, initiative, activity that even arguably involves a contract. And if eligibility is limited to people of certain protected characteristics, that's something that is a big risk factor. And I know I said we're going to get into the practical guidance later, but I'm going to talk about it right now. So the thing that we have been advising our clients is really the same thing that Justice Roberts telegraphed in his majority opinion in the 2023 affirmative action cases, which is Justice Roberts said that while it is illegal in the majority's opinion to give any preferential treatment to student applicants on the basis of race or other protected characteristics, that if colleges and universities wanted to require applicants to write an essay showing how they've overcome hardship and disadvantage and challenges in their life, and if they reference their race or other protected characteristics as being an element of that hardship they've overcome, that's okay, that the universities and colleges can take that into account holistically without engaging in reverse discrimination. And so what has happened is that is exactly what colleges and universities, from what we understand, have been doing for the last almost 2 years. It is also what the Small Business Administration and some other federal agencies started to do last year in the Biden administration, believe it or not. Like the Small Business Administration for decades has had a loan program that if you were a minority or woman-owned business, small business, you could qualify for these preferential loans because it was presumed that you had overcome hardship and disadvantage if you were a minority or woman-owned, majority-owned business, 51%. Been around for decades. Well, the Biden administration, kind of seeing where the law seems to be evolving, starting with the 2023 U.S. Supreme Court decisions, abandoned that and replaced it with essentially a college university type essay requirement where you have to write something showing how you've overcome hardship and disadvantage. And you can reference race and other things like that if that's an element to it, and then making their decisions based on that. So what, not surprisingly, we have been advising our clients is that if you have programs like that and you want to continue them, and I had a phone call with an executive director of a client yesterday, and Kevin, I didn't even fill you in on this, but she wanted, as a recent analysis we did, and she wanted to talk through some of our recommendations. And she said something like, so I need to abandon this program, right? And I said, no, you don't need to abandon that program. What you need to do is consider changing the eligibility criteria to get at your same basic core goals, values, aims for this program, but doing it in a way that kind of tracks with the way the law is evolving. And so that's a really important takeaway if you have programs like this. All right, I've got to move on because I want to make sure we have time for questions. Second big area is employment law. Okay. First off, this is very significant in this Trump 2.0 administration because the Trump administration enforces federal employment laws. I should say they're the number one enforcer of federal employment laws. They can be enforced by others as well. including private plaintiffs, disgruntled, terminated employees, discriminated against employees and whatnot. But Trump administration controls the U.S. Department of Labor, is taking over control of many kind of quasi-independent agencies like the Equal Employment Opportunity Commission. And because of that, we already are seeing, we're going to likely see more of the administration's influence in how federal employment laws are enforced. And so this is another primary area of our focus. And this is nothing new. We've been doing this for the last 2 years since the U.S. Supreme Court's decision in particular. But to the extent that you have in your organization employment practices, policies, programs that in any way are, I use just the banner, exclusionary. If you are giving any sort of preference to certain minority groups, like for instance, the current state of the law based on prior U.S. Supreme Court decisions is that you are allowed to take race into account. This is current law per the U.S. Supreme Court. I am not at all suggesting that this is going to stay this way. In fact, I don't think it will. But right now, you're allowed to take race into account in your employment practices if members of a racial minority were previously excluded from a particular job category, or to remove obstacles such as unconscious bias that prevent employers from having a more diverse workforce. But seeing where the law is evolving, just like the Biden administration did with the Small Business Administration and other federal agencies last year, I think it is something that you want to take a hard look at. Every organization's risk tolerance is going to be different. We're going to talk about that a little bit later. The extent of your risk exposure is going to be different based on the nuances and details of your programs. But to the extent you do that, especially explicitly through your policies and whatnot, you're going to want to take a hard look at that. And beyond that, if you have things like staff leadership acceleration programs that a number of our clients do that kind of give opportunities for those in particular groups of employees who have been underrepresented in the leadership ranks of the organization in the past, and having programs to help boost them up and give them leadership training and opportunities, but eligibility is limited only to people of certain underrepresented minority groups. Those programs are likely on very significant, shaky legal ground, and something you really ought to consider taking a look at, and not necessarily eliminating them, but retooling them to redefine them differently in a way that's not exclusionary, that maybe is designed to bring in people who have overcome hardship and adversity in the past, but are not limited, based on your skin color or other things like that. This is the kind of thing you're going to want to take a look at. And then, of course, while there is this is another theme of our kind of counseling of our clients, there's obviously a heavy focus on this administration and what's going on here and concern about mitigating risk. At the same time, about half of our country, or at least half of our states, are politically blue states that have very different employment laws and very different enforcement of those employment laws. There are a number of state and local even employment laws that, for instance, prohibit discrimination on the basis of sexual orientation and gender identity. In California, for instance, and as you may know or should know, the employment laws are based on where your employees are principally working from, not where your organization is headquartered. So if you're a DC-based organization, but you have a California employee, the California employment laws or regulations require that you have to provide a certain type of anti-discrimination, kind of DEI related training to those employees before they start. It's a legal obligation. I'm not sure if it applies to all employers or only those of a particular size, but my point of all of this is that if you have employees in certain states that have laws and rules that are very different from what we're seeing at the federal level, the federal laws don't override those. You still have to comply with those. Now, there may be instances where these come into direct, the contrast, and we don't know how the courts are going to interpret those. But the federal government's not going to be able to tell a state that it can't enforce its own employment laws in a given area for the most part. At least that's been the law in the past. So point is, you have to take all of these things into account. There's no substitute for consulting with experienced legal counsel in this area in the employment space to make sure you're complying and mitigating your risk, not only with respect to federal law, but with respect to these state laws as well in the employment space. And then finally, real quickly, because this is more predicting what's coming as opposed to what's on the books right now. But as I stated earlier, there are a number of states that are either have or in the process of or are considering laws in their states and executive orders by their governors that kind of enact anti-DEI initiatives at the state level beyond employment. So, for instance, one law that some of you may have heard about, it's currently enjoined, it's put on hold by a federal appellate court, but there's a law in Florida referred to colloquially as the Stop Woke Act, which makes it illegal to provide any diversity-related training to Florida-based employees, including if your nonprofits have any Florida-based employees. Like I said, right now that law is on hold. And that law, by the way, applies to private employers just like it does public employers. There are other states like Texas that have a similar law that prohibits diversity-related training for employees, but that's only in the state government workforce. But what we have heard is that last I read, I think last week, that something like 27 states, primarily red states or all red states, have anti-DEI related legislation that's been introduced in their legislatures. Point is, you need to keep a very close eye on this. I suspect that many of these laws and executive orders are going to apply to private nonprofit organizations, not just those that receive state government funds or that are, state workers. And there's no question that you're going to have to pay attention to this. And states have a lot of different ways that they can get kind of their legal hooks into your organization. Even if you're not based there, you might be incorporated there. You might be qualified to do business there as a foreign corporation. You might be registered there for state charitable solicitation registration purposes. You might have employees there. There are lots of different ways. You might have significant contracts there. There are a lot of different ways that a state can get jurisdiction over your nonprofit, even if you're not headquartered or physically located there. So that's going to be something you're going to want to keep a very close eye on. So that is kind of the lay of the land in terms of the various aspects of legal and related risk that we are talking about here today. As you can imagine, your head is probably already spinning from the last 45 minutes of this discussion, how many things you need to take into account. There's actually one other that right now is not really a legal issue to be concerned about, but we have gotten questions from a number of our clients about it, and that is federal tax exempt status. So right now, there is no known initiative by the IRS to focus on or scrutinize the federal tax exempt status of nonprofit tax exempt entities based on their DEI initiatives, but it's not inconceivable that there may be. There have been some court cases decades ago that upheld like the IRS denial, for instance, of federal 501c3 status to a would-be tax exempt organization that essentially like a KKK type organization. This is back in the 50s, I believe. And the IRS said, no, we're not going to recognize the C3 status of this organization because it's engaging in activities, it might have been the 60s, that are violative of public policy. And that's been kind of a long-standing rule. Like the IRS won't recognize tax exempt status for groups that it deems to be terrorist supporting organizations, things like that. So just because on the face it might have a valid tax exempt purpose, if the organization is engaging something that the IRS believes, and if the courts uphold it, is violative of public policy, then they're not eligible for tax exempt status. It's not inconceivable to think that the IRS might flip that reasoning around or apply it to organizations that it believes have significant kind of DEI related purposes and activities and programs, especially ones I would think that it's really core to their mission. And there are many organizations where DEI is core to their mission. And so that's something to keep a very close eye on. And so when we're analyzing risk, of course, you have to look at all of the different current and potential legal risk at the federal and state level. You have to do your analysis. You have to look beyond legal risk to look at things like, depending what actions you take, or as one client's executive committee told me last week, fail to take, they're concerned about failing to take action, coming out strongly against this administration, that you risk all sorts of potential backlash from members, from donors, from supporters, from funders, from conference attendees, from exhibitors, from sponsors, advertisers, all of the above, any or all of the above, never mind potentially being made a target, by, for instance, House or Senate committees. Some of our clients are under investigation by certain House and Senate committees because of their DEI related initiatives. I expect we're going to see more of that. So you have to, unfortunately, it gets complicated. You have to take all of these different risk considerations, including reputational risk, into account. And that's why I said earlier, the analysis we do for our clients, every single one of them is different. Every memo that we've written for clients is different because their risk exposure is different. The type of risk they face is different. Some organizations, I talked to one CEO and board chair last week of one organization where it's kind of a classic professional association, and they care about DEI. They have some DEI, initiatives, aspects in their practices, their policies, but it's not core to what they do. And for them, for instance, they're very comfortable kind of taking some of the more superficial steps to kind of dress up things in a way that perhaps makes them less of a target. To, for instance, they have a DEI track in their annual conference or a major conference, and they're thinking about taking that out and making it a separate standalone webinar. And that's because we are seeing, in their case, they have a lot of government employees who attend their conferences. We've already seen it with some of our clients where federal workers are asking our clients, are there any DEI components to this conference or training program or whatnot? Because if there are, I'm not allowed to register, or my boss has told me I can't register, things like that. We expect we're going to see more and more of this in the coming months. So you have to take that sort of risk analysis into account. And we have other clients who are saying there's no way we're going down that path. We understand the risks. We know who we are. And this is one thing that Kevin and I and our colleagues have stressed with every client, is that don't change your core values. Obviously, you can't put your head in the sand. You can't ignore some of these risks, some of which can be significant ones, but to the extent, how much federal funding do you receive? Do you hope to receive more federal funding in the future? Obviously, that's going to be a key risk analysis. If there are things that you're doing that seemingly squarely fall within some of the things I talked about in the contracting space or the employment space, there are likely ways that you can modify those eligibility requirements and how you administer the programs in a way that helps to mitigate their risk. Even changing the name of certain committees or programs, and doing it in a way, you can do those things in a way that doesn't run away from your core values, but does it in a way that mitigates your risk. And for some organizations, that's going to be easier to do than others. I think, Kevin, unless you have any closing comments here, I think we're best to open it up for questions and spend the rest of the time, next 20 minutes or so, answering everyone's questions. Do you have anything you want?
No, nothing much to add. I think I'll just put a finer point on that. The risk analysis involves both legal and non-legal risk, and it unfortunately requires very difficult conversations with nonprofit boards, their stakeholders, their members, other people involved in the organization, to the careful balancing act of maintaining your values while protecting yourself from risk where it's appropriate and where it's meaningful. So those are the hard conversations that a lot of our clients are having within their organizations. And sometimes they face backlash if they do take certain actions, or backlash if they don't. So I think that was a really good point by Jeff, just that that's the nature of these hard conversations. It's not always legal risk. It can be non-legal, and that makes it that much more difficult to suss out. But we are looking forward to taking all the questions that we've been seeing a few come in, but we'll turn it over to Mickey to start kind of moderating the Q&A.
And Kevin, just to close the loop on that, we did work with one client that especially just generally out of concern, but also out of concern of folks not showing up or kind of boycotting their upcoming big annual conference. They felt a need to put out a statement, but we were able to work with them. I remember being on a call last week with the executive committee where I said, I hear where you're coming from, I hear what you want to say, but I think there's a way to thread this needle where you can make the statement, the public statement that you want, but also not, become even more of a target of the administration. And they were able to put something out that kind of threaded that needle and worked the way it did. And then the last point is, I know some of you on the call are advisors to nonprofits, but others are nonprofit executives who probably don't have many board members. But to those nonprofit executives on the webinar, I would say very important, and this, all of you who are experienced nonprofit executives know that you never want to get too far out ahead of your board. Sometimes you have to provide leadership to your board. Sometimes you have to help educate your board. I've been doing a lot of presentations on these issues to boards of directors. But my point to you is don't, make sure you're in sync with where your board's at, starting with your officers and your executive committee. But make sure that you're kind of singing from the same song sheet. That's a recipe for disaster if you start getting out ahead of them in ways that your board is not comfortable with. But like I said, sometimes you have to lead them and provide that leadership, particularly in these really challenging times. So why don't we open it up to any questions that anyone has?
All
Nikki?
right. So the first question, I know you touched on this, but I figured you want to elaborate. The question is, if the target demographic for your philanthropic initiative is Black women, helping Black women gain access to education and other resources, would it be prudent to now broaden it out to all women to reduce the risk of being subjected to lawsuits against race-based grant making?
Yeah, so this is a really tough one. And we have a number of clients that fall into this sort of category. And this is what Kevin and I were referring to, what we said for some organizations, kind of DEI is really built into your DNA. I mean, it's who you are. It's who you represent. I mean, Fearless Fund is a good example of that. I don't even know, especially they're not a client, so I don't know exactly what their purposes are. But this is a great example where, if you've been around, say, for decades, and you are an organization that advocates for Black women in various aspects of work and business and life. And all of a sudden to say that we're no longer an organization that advocates for Black women, but we're an organization that advocates for all women. I mean, that would be such a major, major change in who you are. I can't even envision, we haven't yet encountered that in any of the analyses that we've done for our clients, but if and when we do, I can't imagine us making that sort of a recommendation. Now, it's another thing if the IRS starts to, go down the path that I hinted at potentially earlier, and if that could end up having an adverse effect on your overall tax exempt status, that's a different issue to consider. But unless and until we get to that point, I wouldn't abandon your core mission and purpose of who you are. But what I would say is that to the extent you have grant programs or fellowship or scholarship programs that are limited by race, that is something where I would consider opening those up. I know it seems a bit contradictory to say keep your core mission and purpose in terms of who you are, who you represent, but open it up to others. Just like we represent a number of associations of professional associations of women in different sectors. And in talking with some of them recently about these issues, I think every one of them said that membership in their association is open to anyone, including men. That conference, attendance is open to everyone, including men. And so that they're not limiting who can participate in the organization. But for this questioner, if you have particular programs that involve a contract and that are limited only to Black women, that is one where I would consider opening up the eligibility criteria, perhaps including some sort of a demonstration of hardship or overcoming disadvantage requirement, if that's relevant. In order to make yourself less of a target of the Ed Blooms of the world and potentially this administration and Republican attorney generals as well.
Okay. The next one, as an example, the ASAE DELP program is not funded by federal funds, but through generous sponsorship from a DMO. I'm curious how the administration would see this program since it's a private member program versus a publicly available program, and that it's sponsor-based versus a federal grant program.
Yeah, it's a good question. I'm very familiar with the DELP program. I have a number of friends that are DELP members and leaders in that program. This is a good example, and Kevin and I have been dealing with this in the analyses we've been doing for clients, that a number of our clients, and I would put the DELP category into this category of program, have these programs that are limited, by certain protected characteristics in terms of who can participate, but they're not at all employment related. They don't involve, a contract that has some eligibility requirements. There's no federal funding involved. Right now, there's no state laws that we're aware of that prohibit this sort of activity. So when you go through the pure legal analysis, it's hard to point to anything that says this is legally problematic. Okay, again, that might change. see what happens with the IRS in the future, things like that. But right now, it doesn't seem to pose any high degree of legal risk. And so then you go down to kind of that second tier of analysis, which is, you know, potential member backlash, potential reputational risk, things like that. And that's where every organization is different. And knowing ASAE very well and its leadership and its core values, they would face a huge member backlash if they went the other direction and got rid of the program or changed the name or purpose or purposes of the program. I don't see that at all remotely happening. I think the legal risk is very small, if non-existent at the moment. I mean, any creative entrepreneur, enterprising plaintiff's lawyer can start to gin up any claims. But from what I know about the program, I think it poses very low, if any, legal risk at the moment, very low reputational risk by continuing the program. And that's the kind of thing where I suspect that ASAE will continue the program as is. And if we were advising them on that, we would advise them the same. But to keep an eye on continuing developments at the federal and state level and in the courts. Kevin, do you agree with that? Anything else?
I do agree with that. I think, the devil is always in the details. I think for a program like that is intended to encourage diversity very broadly, that's probably going to be just fine, because in a lot of ways it's not actually exclusionary. It encourages and promotes applicants from a diverse set of backgrounds, but as long as it doesn't exclude anyone based on a protected characteristic. I think that one of the key tests that can sometimes tell you the direction you're going in is a straight white man eligible to apply for this program? If the answer is no, and there's also a contract, then you may start to have some issues where you may want to consider some changes. But a lot of those types of programs are open to anyone with the intent that a diverse class be created. What I think we advise a lot of our clients to avoid is having a set list of characteristics, often race-based characteristics that would restrict eligibility. So if the intent is to be broadly diverse and broadly inclusive, that's usually acceptable. But if it is exclusionary in some ways, then that's going to be difficult. The other side of it is the funding piece, right? It's private funding, and that's not directly implicated by any federal or state law that we're aware of. The other issues that could impact that funding is if the funders are getting pressure from their stakeholders, or they have to make some kind of diversity-related certification. If they are, for example, a recipient of federal funds on their end, then some of the flow downs that Jeff discussed earlier, those pressures may come into play. But as it relates to that specific funding, it's not directly impacted, but could be indirectly impacted in other ways.
Yeah, and Kevin, that's a good point, because I think the questioner said, and I did not know this, that it's DMO funded. I don't know if it's coming from a particular DMO or multiple DMOs, but DMOs, while they are private, typically 501c6 nonprofit tax-exempt organizations, their whole purpose is to promote tourism and business in particular, and business like association business in particular states. And if that DMO or DMOs are coming from red states, that are very much taking a closer, even if they don't get federal funds, but if they're coming from red states whose governors and executives are very much in an anti-DEI mode, I think that's something to take into account in terms of funding sources. And one of the things that we wrote an article recently on all of this, and one of the things we said is be sure to look closely at your funding sources and diversify your funding sources to the greatest extent possible. So, for instance, if funding from a particular program like that is coming from a DMO in a very red state, and that is particularly politically problematic going forward, that's something you're going to want to take a look at and try to broaden the funding sources. The last thing I'll say, and I apologize that I don't know this, but I know there's something called a DELP Scholar, and I don't know if that is like a fellowship type program where there's some sort of a scholarship or grant awarded to individuals, for a period of time. But it doesn't, I mean, it matters whether that is in fact the case, but let's use it as a hypothetical. If that was the case, and there's some sort of a fellowship program through the DELP program that involves a contract, eligibility is limited based on race and other protected characteristics, then that's something that is potentially very legally problematic under the current state of the law and where things seem to be heading. And so again, there, like the same advice we gave earlier, if I were advising the DELC program on that, I would say consider opening up eligibility to anyone, irrespective of race and other protected characteristics, but requiring some sort of essay or other submission showing, hey, you've overcome hardship and adversity and things like that in the past. That, to me, seems to be the best kind of current day, current law strategy for dealing with those sorts of issues.
All right, great. Next question, do you anticipate the government sticking to the $5 million cap?
So I think the questioner is talking about I think the questioner is talking about the reference in one of the EOs, one of the executive orders that directed, it was the DEI executive order that recommended identifying, that DOJ and others identify discriminatory DEI practitioners in large nonprofit corporations or associations, foundations with assets of $500 million or more, state and local bar associations. If that's what the questioner meant, that was just a directive to say, look at potential illegal DEI practices in private nonprofit organizations as well. And by way of example, it called out foundations with assets of over 500 million or more, and it called out higher educational institutions with endowments of over $1 billion. I'm not sure that I recall any $5 million reference in anything that's happened in the last couple months. Kevin, anything else come to mind?
No, nothing comes to mind,
Yeah.
but I would just say that is something that the administration is creating by executive order in terms of setting its enforcement priorities, and that is something that can always change. I don't know if they're going to have the resources to go after some much smaller organizations, but in terms of it setting its enforcement priorities, that's something that can always change and really change at any time.
Yeah, and even in that EO, it referred to large nonprofit corporations or associations, and that was separate from foundations with assets of $500 million. So that even that $500 million reference, I think we generally know what sort of private foundations they're referring to there. There are a lot of kind of very large, notable, more politically left-leaning private foundations that have very large amounts of assets and that fund a lot of left-leaning initiatives. We have a number of clients who receive funding from those organizations, and I think that's kind of what was being referenced there. But bottom line, like Kevin said, no one's out of the target hairs of the administration. I think, like Kevin said, organizations that are larger are likely going to be bigger targets. But we have a client that's under a Senate committee investigation because of some, I'll just put it into the DEI category, generally practices. And they're not a particularly large organization, but they're particularly vocal in a particular area that kind of got, this particular Senate committee chair's attention.
Well, if they just missed a couple zeros, that answer works. And if not, shoot us another question so we can focus our answers for you. All right, next question. Can you specifically define DEI programs? What all falls under this umbrella?
A great question, and unfortunately, Kevin and I don't have answers for you. Nobody does, because the administration has never defined it. But I will give you a couple examples, including one I just read about in the Washington Post this morning, and that is that several federal agencies, including the National Science Foundation and including the U.S. Department of Agriculture, are right now, based on the administration's directives, including these executive orders, are scouring their grantees and contractors and research projects for certain keywords, including, like it was reported, National Science Foundation is searching all of their research projects for keywords such as women, diversity, minority, institutional, historically, and socioeconomic, to try to identify research projects. And what they've made clear is that they're not saying that any research project that has any research that involves these keywords is going to be canceled, but it's going to initially flag projects that they want to take a deeper dive in. USDA, I was just reading this morning, is scouring all of their grants and contracts for certain keywords, including the ones I mentioned, and also including some others that were referenced in the article: equity, inclusion, underserved communities, socially vulnerable, underrepresented, and socially disadvantaged. And they actually had one of the senior USDA folks on record in the article kind of talking about how they have flagged those projects and grants and contracts that have those keywords so that they can do a deeper dive and evaluate them, and then determine, is DEI, however they define it, kind of a core part of what this project is about or not. And they've said, and this is just what I've read in the post, that for projects where it's really not remotely a core part of what the project is about, that they are starting to release the funds for those projects. But for others, they're waiting to do a deeper dive. So we don't know exactly what it means. It's never been defined, but we know it's a lot broader than what you might typically think of as DEI. It's certainly a lot broader than affirmative action. It's certainly a lot broader than DEI, diversity-related trainings that employers do. It's so much broader than that. And we've seen it a lot with things like, we have a number of clients that get either grants, cooperative agreements, or contracts, or they're sub-awardees from those projects for conservation-related initiatives that came from the Inflation Reduction Act and other laws that were passed, kind of climate-related initiatives that were passed in the Biden administration. Those are very much being targeted. Those very much kind of fall within this overall rubric of DEI. And it's not surprising. We're sadly talked to 2 clients in the last week. Their initiatives are largely in the immigration space in terms of immigration rights. And one of them, 2 of them in particular, are largely federal funded, one almost exclusively, and they're already making plans to shut down because they just don't see the possibility of this sort of funding continuing. And so these are the things that you have to carefully evaluate your risk tolerance, your risk profile based on all of these different factors. But these are the types of programs and initiatives that are going to be most targeted by the administration. And if you receive federal funds directly or indirectly in these areas, it's something you're going to want to really do some business planning about.
Okay, we have a couple questions left in our last few minutes. This one is, we are a member association, 501c3, and have a DEI committee. Several of our member organizations receive federal grants, but we as the association do not. Is simply having the committee, and if the association is committed to equity and inclusion throughout the organization, from staff to board to committees, is this something we need to take a look at?
Yeah, we had that question in the past week from a client, very similar. And in fact, I just had a question today from a client that we're actually doing a DEI analysis for the association, but a lot of their members get federal contracts. Much like the association doesn't receive any federal funds, but its members receive federal funds. And so you obviously have to take that into account in doing your risk analysis. But to me, just the fact that your members receive federal grants or contracts, at least from a legal perspective, just having a DEI committee, a board committee or other committee or special interest group or whatnot, and it's open to anyone that wants to participate. It's hard for me to point to that and say, you need to get rid of that or something. I think we advised a couple of clients that they might consider changing the name of the DEI committee to something else. We know that, for instance, a lot of large corporations, Fortune 100 corporations and whatnot, and some have just abandoned their DEI initiatives altogether, but we know some have renamed them to focus more on the inclusiveness part and not so much on the exclusiveness part. And you heard Kevin stress that a few times. I think that's a key takeaway here is don't be exclusionary in how you define who's eligible, who can participate. Make it more exclusive. Stress the anti-discrimination aspects of everything that you do, which is aligned with what the administration is saying and aligned presumably with your core values as well. So sometimes it may be worth considering a name change or something, but just simply having a committee like that, it's hard for me to identify a lot of legal or even business risk there. But every situation is different. And like Kevin said, the devil's in the details.
Yeah, I would say, some of the potential, business risks is that, if your C3 members who receive federal funds are, turning to you and asking, does any of your conference have DEI related content? If so, I can't attend. Similar to how the federal workforce is looking at some of those issues. It's a little bit less about, what the law says about your organization and a little bit more about how your members interpret how it applies to them. So if your members think that they can't attend any event that has any DEI component at all whatsoever, it may be worth having a conversation with people about, this is what we do, this is what we don't do, and you have to make your own legal determination here about your own risk. But we think this conference is okay, as an example. But it could start to open up, business and financial risks if, for example, a large contingent of your membership is unable to participate in a certain revenue generating activity. So that is something that it's much more of a business risk analysis than a legal one, but it's something important to take into account.
Yeah, and one finer point on that, and then we'll get a wrap up, is that comes back to my earlier point. Don't forget about the states. Okay. So like the client that I was just referring to, their members get federal funds, but they also get a lot of state funds, including a lot of Infrastructure Act funds, from the big infrastructure bill that was passed. Much of that is federal money that goes to the states and then goes to individual contractors, for instance. And if, for instance, the federal awarder contract letter says, we are going to require, for states that receive our money, we're going to require that you have all of your contractors that you hire to carry out these infrastructure projects certified that they don't have any DEI initiatives or are using our money to attend any conferences that have DEI trainings or educational content. That's something we need to keep a close eye on. And I can also see a lot of red states doing that in and of themselves with their own monies and requiring those sorts of certifications. So sorry, this makes the analysis much more complicated, but you have to take these things into account. I think we need to stop there. Mickey, Derek, turn it back over to you guys to wrap things up.
Yep. Thank you very much, Jeff and Kevin, for this very informative and excellent session today. And on behalf of FAR, we just want to thank all of you for attending today. I hope we answered most of the questions. We'll get to the one or two maybe we didn't get to after the fact, but please keep an eye in your inbox for the survey and for notices for future FAR events. Thank you all for attending and have a great day. Goodbye.